Hey everybody, welcome to Active Self-Protection Extra. Today on John's Briefs, again with Terry Johnson from Firearms Legal Protection. More than that, my good personal friend, Terry Johnson.
Same here. You're my good friend.
I appreciate that.
He's a good guy.
Don't lie to me. Anyways, today I want to talk about, and this could stretch into two videos for sure. We recently had the grand jury come back in Louisville, Kentucky, and issue no true bill in the death of Breonna Taylor. And that's causing more riots in our nation. And so I want to talk to the attorney about the grand jury process and how this works, what the pitfalls are, where we might have implicit bias, but how the system works and whether it worked right in this case. Today's video is brought to us by Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners with a 24/7 emergency hotline and plans designed specifically for self-defenders. They are offering a discount on their plan to ASP fans, so hit the link in the description for that. So I want to say again, Terry, thank you for coming on the channel, man. This kind of stuff, I think the people that watch it recognize this is invaluable education. Thank you for providing it.
Thank you for having us, and we as Firearms Legal are very happy to sponsor John's Briefs, and I mean, what a great partnership. You know, we give education and protection, and you put it out to all your subscribers, and we really appreciate us working together to get this message out to everyone.
I really think it's the best part of the partnership of Firearms Legal Protection. There's a lot of good parts, and this is the best one, so thanks for that. Okay, so we saw what happened. So we know that there was, in my opinion, a lot of media information that came out immediately after Breonna Taylor's death in March.
Yes.
And then there's been a bunch more. Also, by the way, for those of you who are watching this on video, we're at the Active Self-Protection National Conference this weekend. So this is why we're in this environment. We actually have a live audience with us. We're going to take questions from them as we're going, so you get to be involved in that process. So at any rate, we had Breonna Taylor was shot during a warrant service.
Correct.
And at first we heard things like there was a no-knock warrant, that they just shot without any provocation, and those kinds of things. It seems that when the grand jury came back, they came back no true bill.
Right.
And of course that causes a great amount of angst. And I think, I get it. I mean, I think that the black community hears this and hears there's just another instance where there's injustice done. But before we do all that, talk to me about how a grand jury system works, Terry.
Sure. Well, let me say this. In this country, you have pretty much two systems. You have a grand jury in in some states, for example, Kentucky, Texas, a few other states have grand juries. I can't think of them off the top of my head. In other states, you have what's called a preliminary exam. For the purposes of this, the grand jury is a system that's put together to make sure that what the prosecutor wants to bring is good enough to move it to trial. So what happens is they pick, and again, I'll use federal because federal courts use grand juries. They'll pick approximately 24 people. They'll put them in a room, and the prosecutor alone presents a case.
So let's talk about who's picked here. This is my understanding, it's the same as another jury selection, right?
Correct.
So the same as a jury as a finder of fact would say in a federal or a state case that says they're the ones who decide, was this in line with the law or not? A grand jury is that same pool of people.
That's correct, but the difference is the defense has no say in it. So, for example...
Well, that's a huge difference.
Oh, it's huge, yes. So, for example, let's say you're charged with something and the state decides to do a grand jury. Well, guess what? You have no say on what evidence is presented to the grand jury. You have no say on the people that are picked for the grand jury. You don't even have the opportunity to be in the room. Now, some states will allow, you to submit like a statement or certain things. But again, this is merely for the purposes of, is there enough evidence to move this to a trial?
So
that's it.
In a trial jury, we have what they call voir dire.
Yes.
Right? Don't I sound smart when I say Latin words? Right? Hanging around lawyers makes me think about terms. But in voir dire, both the defense attorney and the prosecuting attorney, they get, as they ask jurors questions, they get what they call peremptory strikes. So they can say, I don't want that person on my jury, and I don't have to tell you why.
Exactly.
I just don't want that person on my jury. And then they've an agreed upon number of strikes.
Correct.
And then they also have where they can say no for cause. this person should be removed and not count against my strikes.
Very good. Yes.
Do I have it?
You're going to law school. We're going to get you there.
No, don't you put that evil on my head, Ricky Bobby. I have all the time in the world to go to law school. But no voir dire in a grand jury.
No.
So is it just the prosecutor gets to decide which 12 or 24?
Well, I believe it's picked. They go into a room. And again, my experience with grand juries is a little limited because I come from a state that does preliminary exams.
Okay.
And we'll talk about that later.
Sure.
But here in a grand jury, you get 24 people. I'm just talking about federal. They go into a room. Certain states may limit it to 12 or 6. It all depends. Again, jurisdiction. Mm-hmm. You go in, and the prosecutor literally presents his or her case, and they're just telling one side of the story. They're not saying, for example, in the Breonna Taylor situation, they're just saying what they believe the officers did and what they want to charge them with. That's it. The defense has no say whatsoever in that.
So I'm sure whether we're talking about the officers in this particular case or in any case, I mean, obviously there's rebutting evidence. There's a different theory of what happened that day to the defense, but the prosecutor here gets every advantage.
There's an old saying, the grand jury can indict a ham sandwich if they wanted to.
A ham sandwich. Now, of course, I do think, I've also, if I understand correctly, the standard of a grand jury is not the beyond a reasonable doubt standard that is required in court.
Correct. Is it enough evidence to move this to trial? Has the prosecutor shown us enough to say, for example, in this case, should the officer be indicted on, let's say, murder, first degree, second degree, is it manslaughter, is it whatever they want to come up with? Has the prosecutor met those elements in order to move this to a trial?
So is that a probable cause standard?
Pretty much a probable cause standard.
So listen, that's the same standard that an officer would use to arrest someone. It's not, I'm sure beyond a reasonable doubt that there's an actual crime. It's that I have probable cause that it's likely that a crime was committed.
Correct. And in this case, if you go back to the Breonna Taylor case, what you're looking at is, what did the officers do? Did they come in? And they're looking pretty much at their intent. Basically, did the officers come in? Did they intend to shoot Breonna Taylor? I don't know, again, what evidence that the Attorney General put forth. I don't know, and again, by law, they're supposed to put as much forward as possible. And let me just say this, and it's sealed. And the advantage of it being sealed really comes down to this. It comes down to this doesn't give the defense an opportunity to come back and rebut it, even at a trial, once it goes to trial.
So this is, again, if you don't get a grand jury indictment, there is no way you're going to get a criminal conviction.
Well, pretty much, yes, you're right. It could happen, but again, the grand jury is the first stopgap.
Right.
So you get an officer that arrests you, and again, you have a probable cause here in a preliminary examination or a grand jury. That's the first stop where someone comes in, someone being the people, to say, nope, this isn't right. This needs to stop right here.
No more prosecution.
No more prosecution. So it puts the prosecutor in check. At
least some standard there.
Yes.
And so again, though, if you're like, wait, we want to make sure if we say that an injustice was done here, then what we want is we want to have a conviction. But if we can't get a grand jury indictment, there's no way. Now, I know somebody's going to say, well, wait a minute, but the prosecutor doesn't have to share everything with the grand jury. And so if the prosecutor softballs the case, then I could still have bias in the case because the prosecutor doesn't do their best.
Generally, a prosecutor wants a jury to make a decision. Okay, a prosecutor wants to put things forward, and all of my friends who are prosecutors, listen, there are some cases they don't want to bring forward, but they have to. And no one is going to, I'll say, softball something, especially this big, and risk what's going on in the city of Louisville right now.
Yeah, I guess I'm looking at that and going, if I'm the prosecutor, I go, look, I got to present the case that I have and present it well, because if I don't, then A, the mob's coming to my house.
Correct.
So that's a self-interest thing. And B, I'm violating my oath.
Exactly. And again, this is a stopgap measure, and it's there for everyone's protection.
Wow. So, and in my opinion, so I look at this, and I want to share with you guys and share with all of you, I'm sensitive to the cry in our country for for justice, for making sure that the system works as intended, because it hasn't worked as intended for hundreds of years. I mean, we could legally, I mean, when you say the legal system, right? So it's legal. Well, gosh, guys, 100 years ago, you could legally own a human being almost, for gracious sakes. That's not cool. So we decided later that law's not just. We got to change that.
Correct.
So for the ladies in the room, right? Until 100 years ago, you're like, yeah, you can't vote. You're like, and we decided, no, that's not just. We got to fix that, right? So we can fix laws. We can
Absolutely.
change things.
Absolutely. And there's a way to do it, and again, I'll say this, protesting, fine. Rioting, not good.
Not good.
I mean, because again, the message gets lost in what you're trying to do. Because you have some people that are out here that are, I'll use this as an example. You want to fix a law, but breaking into a department store and running out with a, 70-inch flat screen, how is that justice?
Yeah, I don't think it is. So in this case, I get it. And I say that not flippantly. I get that people they say, wait a minute, they hear another instance of what feels to them as an unjust action. They feel like the cops killed somebody that shouldn't have died, right? And it doesn't seem from anything that we've seen that Breonna Taylor was a terrible human being. I mean, okay, but what we did see, the warrant was for her home.
Correct.
So they weren't at the wrong house. They did get a no-knock warrant, but they knocked. And they have multiple witnesses that said that they actually knocked and announced themselves.
Correct.
Her current boyfriend, it was about her ex-boyfriend who was a drug dealer, and they were looking at him for a drug trafficking thing that they wanted to indict him on. They know that her car drove the guy around, the ex-boyfriend around recently, and it was her current boyfriend in the house that shot first at the cops. And honestly, I mean, listen, when I'm serving a warrant, I'm acting as part of the people. Somebody shoots at me, I'm shooting back. There's no question there. I do think that to say, okay, wait a minute, she wasn't armed, she wasn't shooting, it's terrible that she would get caught in that and that she was shot and killed. And that was wrong.